So we'll hand over to Chris Hanson, who's going to speak on disability claims on insurers and superannuation funds.
Thank you, Geoff, and thanks to the rest of you for coming out at some ungodly hour on what was a freezing cold morning. Ideally, it'll be better by the time we get back out there. As the program says, I'm going to have a brief chat about disability claims on insurers and superannuation funds. In the half an hour we have, it's going to be a general rather than a detailed chat. I'll be happy to answer questions either afterwards, although I'm going to have to bolt fairly hard on 9 o'clock, or I'll probably regret this. My contact details are on the slides. Now, as barristers, we rarely get a chance to use slides, so this is probably going to be a disaster, but you've been warned. I'm going to talk about two main types of benefit, being income protection and total and permanent disability. I'll talk briefly about the sources of the benefit, i.e. what gives your client the right to the particular benefit, and how to assist the client in obtaining the benefit, whether that be by the claim process on the insurer, a claim on a trustee, or through the court process. And I hope the last part doesn't alienate the solicitors for insurance companies who are in the audience, but it might assist in relieving their frustration with receiving inappropriate material on what are otherwise quite good claims. I'll make a few observations about the task facing courts in assessing this sort of claim and the evidence that should be before the court, and finally some general observations on the duties of insurers and trustees and some alternatives to the court process. Let's see if this works. Well, there you go. I said the two main types of disability benefit are income protection or salary continuance and total and permanent disability. Income protection, as the name suggests, is there to protect an income stream. It's a periodic payment to cover a lost ability to earn income, and typically it's looked on, particularly by insurers, as a temporary benefit. There are people who are on income protection forever and ever, but it makes the insurers very nervous. Typically it's there for a period while somebody can't earn until they can. In some cases it'll have a 2-year limitation. In many cases it'll have a change in definition after a couple of years. And sometimes it also provides for permanent disability where someone can work but in a reduced capacity. The other main benefit, and the one which generates the bulk of litigation, is total and permanent disability. In contrast to income protection, that's a once and for all payment. It's a lump sum to cover the lost ability to earn any income. And it usually requires a total and permanent disability to engage in own occupation or any occupation for which reasonably suited. And that's generally the battleground, but we'll come to that a little bit later on. Two sources of benefits, one under an insurance policy and two under a trust deed or trust rules. Policy first, a policy can be, as I said in the slides, private. That's somewhat less common, but that'll be where your client's entered into an insurance policy with the insurer on their own behalf. Self-employed often do it, but the usual source of insurance claims is group insurance, where it's been provided as part of an employment package or superannuation, and the party taking out the insurance is the trustee or employer, as the case may be. And the other source is under the trust deed and trust rules, and that's almost inevitably a part of a superannuation package or part of being in a superannuation fund. Now, I'm indebted to Morgan McPhee, who's sitting up the back there somewhere, for telling me that the latest data shows that there are over 11.5 million Australians with some level of superannuation cover. So this is potentially quite a big industry. And superannuation almost always carries some entitlement to a total and permanent disability benefit. It may carry an income protection or salary continuance benefit, but usually carries death and total and permanent disability as a part of the savings aspect or in addition to the savings aspect. So I'm going to be ducking backwards and forwards between insurance policies and trust deeds and rules. First, talk about insurance policies generally. There we go. Trite point, but often overlooked. It's a contractual right. If you're acting for a client who's enforcing a claim on an insurer, you're enforcing a contractual right under the insurance policy. So that's quite distinct from slip and trip that we've been dealing with earlier, where the claim's founded in the common law or under statute. The claim here is founded in the precise provisions of the policy. So let me stress it again, you need to read the policy. Read the bloody policy. Always read the policy. It's surprising how often things get well up the track and nobody's had a good look at the policy. So it's going to have definitions of totally disabled, totally and permanently disabled, whatever it might be. Your objective is obviously to satisfy the insurer initially, because it's cheapest if you can get it done before the issue of proceedings, but to satisfy the insurer and if necessary the court that the client's within the terms of the policy. And there'll be medical material, there'll be other material, and we'll come to that slightly up the track. And obvious point at the bottom, if it comes to court, it's breach of contract. It's all of this. Claims under trust deed and rules, similar, except that instead of reading the policy, you're reading the trust deed and the trust rules, which is more voluminous and more difficult. But almost always, what will happen in the trust deed and rules as regards disability benefits is they will pick up any definition that's an insurance policy. The trustee typically farms out the liability. They don't self-insure. They'll have an insurance policy with an insurer covering total and permanent disability or income protection, and almost inevitably the trust deed will say total and permanent disability means whatever any policy of insurance we have says it means. So generally you're just looking at the policy, but you need to look at the trust deed to find out when the benefit accrues, what the entitlement to a benefit is. So again, read the provisions of the trust deed. And in court, a claim under the trust deed is cast in breach of duty by the trustee. I've been talking about definitions, so I'll just talk about a couple of typical ones. Income protection first. Somewhere in the policy you're going to have an insuring clause. It says we will pay the benefit when. We will pay a total disability benefit when, or a partial disability benefit when. So that's the first step. This is when the insurer will pay. And for income protection, typically it's going to say we will pay the benefit when you are totally disabled. And it'll have a clause something like I've provided there. By reason of illness or injury occurring during the policy period, so there's a few things you need to think about. Did it occur during the policy period? And typically it'll say for the first 2 years of any period of total disability, the insurer is unable to perform any one income-producing duty of their usual occupation. Now, as far as the plaintiff is concerned, that is a doddle, any one income-producing duty. A barrister, for example, if I can't get into court and speak, but I can sit in chambers doing paperwork all day, that's okay. I can't do one income-producing duty of my occupation. I can be off on income protection while the disability lasts. As I said earlier, it's conceptually at least a temporary benefit. So often there'll be a step down in the clause. Following the first 2 years of a period of total disability, the insured's unable to perform any occupation for which they're reasonably suited by education, training or experience. And that's a more fertile ground for dispute, because insurers will be saying, oh, well, they can be a car park attendant or a console operator or work in a call centre, whatever it might be. And we'll come to that dispute a little later as well. And typically it'll also require that the insured's under the regular care and attendance of a medical practitioner. Partial disability, not always there, but it's the return to work provision. You've returned to work, but by reason of the disability you're earning a bit less. The crucial thing is what you need to do in relation to these clauses, and it sounds obvious, but it's surprising how often it doesn't happen. You need to provide evidence that the client is within the policy definitions. So back to the fundamental point, read the policy, work out what you have to do. Initially at the claim stage, because many claims are made through solicitors, provide appropriate medical evidence. Evidence of the injury or illness, evidence of the effect on the ability to perform initially any one income producing duty. Make sure that your medical professional knows what question they need to address. If necessary, send them the policy definition. They're not providing an opinion on whether somebody's within it, but it gives them some context for what they need to report upon. Report upon our client's ability to do his usual job. What aspects of his or her usual job do you say you can't do? So you need to target the medical evidence to the policy definition. There's also going to be some factual evidence, because it'll be when the illness or injury occurred, the period when somebody's prevented from working. But again, go back to the policy definition, look at what you need to satisfy, provide the insurer with all that. Becomes much simpler. Otherwise, you can end up in the never-ending spiral of there's a medical which doesn't quite satisfy the definition, the insurer writes back, it goes on for quite some time. If it's income protection, you've got a client who's not being paid anything and is getting a bit tense, so it's easier to do it right first up. If it can't be dealt with at the claim stage and it ends up in court, you're going to need, as well as cogent evidence that the client fits within the definitions of the policy, the history of the claim. It's good pejorative material often, but if it's taken an insurer a year and a half to come to a decision, it's handy to have all that before the court. Even if it doesn't affect on the interpretation, it doesn't affect the interpretation of the clause, it's good pejorative material if somebody's been jerked around for a year and a half. It's difficult for insurers because often it takes quite some time to assess, but courts are fairly impatient about all that. Total and permanent disability. I said earlier, this is where most of the litigation occurs, and it's because of the definition of total and permanent disability. There'll be an insurance clause, we will pay a TPD benefit if, and then a definition of total and permanent disability, and that's a typical formulation. Having been absent from work by illness or injury for a minimum of 6 months, the insured is, crucially, in the opinion of the insurer. So that's what generates litigation. There's room for difference of opinion between various people, and opinion of the insurer. It needs to be a reasonable opinion, but if an insurer can reasonably come to a conclusion, then it's open to it. The second battleground is later in the definition, following consideration of medical and other material, incapacitate to such an extent as to render them unlikely ever to engage in or work for reward in any occupation for which they're reasonably suited. It's very difficult if you've got a client who's a manual labourer at 40 with a bad back. Insurers typically will think, well, they're 40. They've got potentially 20 years in the workforce. Are we satisfied? Is it our reasonable opinion that this person is never going to work again? So that's where the battleground lies. It's an opinion, and ever work again in any occupation for which reasonably suited by education, training or experience. And again, it's the problem with a 40-year-old labourer. What is it they can do? Education, training or experience. Can they be a car park attendant? Can they be a console operator? When you see responses from insurers that suggest car park attendant, console operator, you should have a warm inner glow, because it's usually the last resort. There needs to be some reality check on reasonably suited by education, training or experience. There's authority on it, but it's not worth citing generally because each authority is on specific circumstances and a specific policy wording. But I just stress that this is the fertile ground. You will get, in our opinion, they can do X. Now, I've sketched on this while I was talking about the definition, but what you need to do in terms of total and permanent disability is provide evidence that the insured, the client, is within the policy definition. And crucially, the second dot point under medical evidence, reasonably suited by education, training or experience now and in the future. What happens all too often is there's been a TAC claim or a work cover claim, there's a bundle of medicals for that, and the medicals for that will say, yeah, they can't do their own job, they've suffered this injury, the injury is relevantly connected with a motor vehicle accident or a work incident or whatever it might be, and that's that. The insurer gets theirs and quite rightly says, well, they don't address future capacity, and they almost never address future capacity. Unless you're getting medicals specifically for this purpose, they're not going to give a prognosis. And doctors are always unwilling to give a prognosis. Anyway, what's this person going to be like in 5 years? And a medical which says It's difficult to give a prognosis. Will cause an insurer to rub their hands together and say, beauty. There is no material provided by the plaintiff which talks about future capacity. Needs to be addressed. Again, there's no harm in sending the policy definition to the doctor. Not to ask them to comment on it, but to say, well, look, here's the claim being made, this is the definition. What do you think about his or her ability to do their existing job in the future? Any other jobs you think they'd be able to do or have trouble doing? And often it'll be something like chronic pain syndrome, and helpfully for a plaintiff, a doctor will say, well, by reason of the ongoing pain, it's difficult to believe they'll have the concentration to do anything. But that's the sort of thing you need to address. Future capacity, essentially to do any productive employment. There's medical evidence. The rest is somewhat easier. Factual evidence. When did it occur? Is it within the policy period? Usually, as I said, the definition will say having been absent from work for a minimum period of 6 months, so somebody's got to cover the 6 months. Challenging the decision in court in a total and permanent disability claim is, the progress of the claim is more crucial than it is in income protection because of the opinion definition. As I said a moment ago, opinion provides insurers with quite some leeway, and there's plenty of authority to say that reasonable people can reasonably come to different conclusions. But the opinion has to be reasonable, and there are other grounds of attack. So if it's taken too long to assess the claim, well, the court might have a look at it. If it appears from the correspondence from the insurer that the policy definition they've been looking at isn't the one in the policy that affects your client, believe me, that happens, then the court's more keen to have a look at it. If it appears that one aspect of disability or one set of medicals has been considered in preference to others, then the court will more readily have a look at it. So if challenging the decision in court, evidence of the history of the claim and correspondence is going to be quite important, if nothing else in creating an impression for the court, but also in dealing with the question of reasonableness and whether an insurer has considered the correct question and given it due consideration. I can skip through this fairly quickly because, as I said earlier, the trust deed is going to be very similar, and typically it's going to pick up the definitions out of any insurance policy, so all the same considerations apply. The question challenging a decision of a trustee is somewhat different because it's a trustee's discretion, but the courts are increasingly willing to treat superannuation trustees' decisions differentially to an ordinary trustee. I haven't provided the authority, but have a look at Finch and Telstra Super. I'll say it slowly. 2010, volume 242 of the Commonwealth Law Reports at 254, so fairly recent. I think it was in the last published part of the Commonwealth Law Reports. And you'll see there the court's quite keen to distinguish the approach in a superannuation case from an ordinary discretionary trust or a testamentary trust, whatever it might be, whereas traditionally they've been treated as the same. So the days of trustees being able to refuse to give reasons, probably over, don't know. Again, the history is going to be important to trustees because while they have a discretion, the discretion has to be appropriately exercised. Has to be reasonable, no relevant considerations, take into account all relevant considerations, that sort of thing. And that's where the history of the claim is crucial because trustees do often write back. They'll often assess the claim in the first place without legal advice. They'll often send letters that the lawyers wishes to God they didn't. And all this is useful in assessing whether the trustee's decision is open to attack in the court. Claims for these benefits in court generally. Typically, if it's a benefit which accrues under a superannuation fund, both the trustee and the insurer will be parties. are usually joined as first and second defendant. There's a difference in the approach of the court to income protection or total and permanent disability. Income protection, because of the definition, unable to do any one income producing duty, they run very rarely, and it's usually a matter of the court just reaching its own conclusion on the evidence. Having a look at this material, balance of probabilities, can this person do all the income producing duties of their occupation? And if it's got to the stage of any occupation for which they're reasonably suited by education, training or experience, again, it's relatively easy for the court because it's an up-to-date question, if you like. It's the question before the court today. Looking at all this material today, the court weighs the material and reaches its own conclusion as to whether the plaintiff can do any occupation for which they're reasonably suited. Total and permanent disability is a different can of worms because of this opinion definition. What you're seeking to do, as I've said, is challenge the opinion. You need to establish that the opinion was not reasonable. And the court will look first just at the material that was before the insurer at the time of making the decision. So you might have some red-hot materials from last month or the months before, but if what's being challenged is a decision made 18 months ago, the court initially is looking at that material. And could any reasonable insurer have come to the conclusion that the client wasn't totally and permanently disabled on that material? So a corollary of that is it's important to get the good stuff before the insurer early, rather than fix it all up just before trial. But what's being initially considered is, was the opinion reasonably able to be arrived at? If so, plaintiff's case drops dead right there. If not, the court will continue on to assess for itself whether the plaintiff is relevantly disabled and meets the relevant definitions. As regards trustees, the last bullet point above expert evidence there, it's an important point that a trustee is required to reach its own decision. There's a regrettable tendency for trustees who've insured out the benefit to get the response of the insurer. So, well, the insurer's knocked it back, that's that. They can't do that, and that's a ground of attack in the court, that they needed to have properly considered and reached their own decision. It's theoretically possible, if you succeed against a trustee, for the court to remit it back to the trustee for proper consideration. Almost never happens. If the court comes to the view that the trustee has engaged in a flawed process, the court's very keen to substitute its own view. Generally speaking, the court's only going to come to the conclusion that the trustee's engaged in a flawed process if it finds that the plaintiff is relevantly disabled, and at that stage, as a defendant, you're well up the creek. Expert evidence, as I said before, it's going to be medical evidence and it needs to be relevant to the correct question. And I know I'm saying that a few times, but it needs to be said a few times. We've got to address the future aspect if the future aspect's in question. I've said that you can send the definition to the doctors, no harm in that, but beware, letters of instruction to doctors will be discoverable, they will be asked for. Some doctors are keen to go into bat. You'd hope they haven't provided any draft opinion which has been later altered at the suggestion of the solicitor, because that will all be discoverable. So treat your medicos as you would any expert. Assume communication, written communication with them is going to be discoverable. Assume that your letter of instruction is going to end up in the court being put to the expert while they're in the witness box. Be a bit circumspect. I've seen cases where solicitors have effectively suggested opinions to medicos, suggested appropriate conclusions, suggested a paragraph of the following form. And if that ends up in the expert's reports, then the credit of that expert's out the window. So be careful. Now we're rattling through this. So odd for a barrister. Ordinarily we can go on ad infinitum. Just a couple of things. When you're making a claim in the court, don't forget about interest. And it runs not from the time of issue. There's interest provided for under the Insurance Contracts Act which runs from the time it was unreasonable for the insurer to have withheld payment. Query when that is. It might be the time of the first refusal, but sometimes it takes an insurer 18 months, 2 years to get to a first refusal in a total and permanent disability claim. So it might be interest from, who knows, 90 days after the claim was initially made on the insurer. But keep in mind, insurance doesn't have to be from issue. You can claim insurance back to the time it was unreasonable to have withheld payment. Nobody's quite clear as to what the rate is in the Insurance Contracts Act. It's provided for in the regulations. I don't think anybody understands it, but typically it's assessed at between 8 and 9% per annum, simple interest. Utmost good faith is an interesting question because there's a provision in the Insurance Contracts Act which provides that all parties are required to act towards each other with utmost good faith. That impacts on how the claim's assessed by the insurer. It impacts also on the plaintiff, on what materials provided. The duty of utmost good faith cuts both ways. And it's an interesting theoretical construct, if you like, but it almost never goes anywhere in practice because breach of the duty of utmost good faith doesn't take you anywhere that the claim isn't already taking you. But it's often a useful thing to throw in correspondence with insurers. We remind you of the duty of utmost good faith. So, worth knowing it's there. The reciprocal obligation of utmost good faith extends beyond the parties to the contract because this can be a bit of a can of worms. If a trustee has an insurance policy, then the insurer and the trustee are the parties. The ultimate beneficiary, the employee or beneficiary of the super fund's a stranger to the contract. There's quite a lot of murky law on this, but practically what happens is insurers just assume that the ultimate beneficiary is entitled to make a claim and nowadays almost never take the objection. So you can run the claim as if the employee or beneficiary was in fact a party to the insurance contract, and the duty of utmost good faith extends both to them and from them. A final aspect of the duty of utmost good faith is duty to provide material which reasonably requires comment. That's happening now, it appears, as a matter of course. But some years ago it wasn't unusual for insurers to make a decision on the last medicals that they had obtained without any reference back to the plaintiff or the plaintiff's medicos. What you'll typically see now in the correspondence is a detailed letter from the insurer prior to making the decision saying, here's all the material we currently have and that we're going to be relying upon. We'll give you 21 days to comment. If you don't get that, it's fertile ground for challenging the decision because the duty of utmost good faith has not been complied with. There hasn't been due process. But mostly it seems to be happening now. Point to take away from that is that you're entitled to know what it is that the insurer is going to be considering as opposed to has considered. You're entitled to know beforehand in case there's material there that needs comment. And you should also get surveillance. If surveillance is going to be relied upon, you should get a copy of the surveillance report and a copy of the DVD so that you can appropriately comment. Different once the court process has started because then there's the question of privilege, but at the claim stage you should get all the material that the insurer or the trustee, as the case may be, I've been rolling them up, is going to rely upon. Fiduciary duties, last point, very similar to utmost good faith. It requires the trustee to have proper regard to the interests of the beneficiary. Rather too often trustees there are a board of trustees, there are a number of employee members, there are a number of employer members, and often it operates as if they were awarding a pay increase or whatever it might be. They can be quite obstructive. They forget that they've got a duty to have proper regard to the interests of the beneficiary. You'll sometimes see that in the correspondence. Lastly, a couple of alternatives to the court process, because the court process is expensive. First, the Financial Ombudsman Service, used to be the Life Insurance Complaints Service, only in relation to insurers, not trustees, and it has some financial ceilings. For income protection, it's only under $6,700 a month. It's going up to $7,500 next year. And there's some conflict between in the terms of reference for the Ombudsman's service, but I think they won't go over $280,000 for TPD. They're worth a call or a chat. They're pretty helpful. The reason you would use them, A, it's cheap, and B, most importantly for plaintiffs, the participating insurer is bound by the decision of the Financial Ombudsman's service. The plaintiff, on the other hand, isn't. So you can treat it, if you like, as a bit of a free kick or a dress rehearsal. If you're successful, good, client gets the benefit. If you're not successful, doesn't preclude going to court. There are terms of reference. I've provided the website reference. You've got terms of reference to the Financial Ombudsman's service. They're quite detailed. It'll tell you what they'll consider, what they won't. But they employ case management officers, and they're quite helpful. Superannuation Complaints Tribunal in relation to decisions of super funds. Crucially, though, unlike the Financial Ombudsman's service, if you go to the SCT, you are stuck with it. Whatever the SCT decides, and you are bound by. The only appeal is on a question of law, and it's to the federal court. It's probable, I should say, that the SCT is less sympathetic than the county court, but who knows? I'm less fond of the SCT approach than I am of the Financial Ombudsman's service approach anyway. And I think that's it. Do you want to come back and call for questions, Geoff?
I will. Thank you, Chris.
Thank you.
Very thorough presentation. Right, have we got any questions from the audience? Yes?
To Chris,
I was hoping to.
Yeah, no.
Sorry.
We'll bring Fiona over here too in anticipation, I think.
Chris, you talked about the trustee being obliged to give reasons for decision. Yeah, okay, I accept that. In my experience, the only reason or reasons they give is that the claimant, is not totally and permanently disabled.
Yeah, traditionally that's the approach. They seem to go beyond that more and more now. They'll say not totally and permanently disabled in that they are able to engage in the following occupations, or in that we're of the view that the medical material provided doesn't disclose that they are sufficiently disabled, and sometimes they'll list the medical material and what they've relied upon. So the traditional view was they just said, no, we've decided to deny the claim. Increasingly it's going beyond that and getting more detailed, and I think that's ultimately what's going to happen. It'll become as detailed as the sort of letter you often get from the insurer.
Thank you.
Harry?
Chris, my limited experience in this area, I wonder if there's any tricks in attempting to get a trustee to expedite its decision.
Yeah, good luck. No. You can speed an insurer up because the decision by an insurer will be made typically at claims level, and there will be a person with the carriage of it, with a supervisor, etc. Trustees' decisions ultimately are always made by the Board of Trustees, which meets once a month or once every 2 months, and it takes its own sweet time. They'll delegate reports off to some sort of committee. Yeah, you can't speed a trustee up, I don't think.
They meet once a year, I think, my experience.
Down the back, Michael. I'll ask Chris one while the microphone's moving. If in order to try and settle these cases, a TPD case, there may be a lump sum of 200,000 involved or something like that. Are the insurers pretty flexible in terms of a payout? Like, might you settle it for 50, 150 or something like that?
Like most litigation, not much runs. There will be mediation as a matter of course in these things that, I don't know what the stats would be, the overwhelming majority settle. It must be 90% settle.
For somewhere between 0% and 100%,
For
depending
somewhere
on the
that
relative merits?
The solicitors for the plaintiff are prepared to accept, and the solicitors for the defendant are prepared to recommend. It'll be out there.
Okay.
Yeah.
My question was in relation to the interest under Section 57. Can that only be charged if there are proceedings, or can that be charged if you think that, or can you ask the insurer to pay if you think they've taken a considerable period of time to decide?
Yeah, it's entirely independent of proceedings. So it's from the time it was unreasonable to pay no matter what. It can become part of settlement negotiations. Look, our insurance contract act interest is this much and our post-issue interest is.
But I'm thinking more where they've actually granted the benefit, but it's taken them, say, 18 months, 2 years to get there.
And we'd like another 30 grand for interest.
Yeah.
Yeah, that's open.
Okay.
Yep.
Yes. Can we just wait for the microphone?
Yeah, sure.
I think this
Sorry.
means that I don't have to repeat the audience question if you use the microphone.
Chris, you were talking about jobs such as manual labourer doing something like working in a console. What about someone who's a barrister or a surgeon? Would they look at income as well? I mean, if they...
It's supposed to be, and they're very rubbery terms, it's supposed to be comparable status. So they've had cases, for example, a chiropractor who perhaps could be able to lecture. No, in that particular case. But it'll depend on the particular circumstances of the individual and the particular policy wording. But it's supposed to be comparable income, comparable status. You're never on strong ground for an insurer with any occupation for which reasonably suited. The courts are generally reluctant to force somebody into another field unless it's a pretty good fit.
One more from Naomi. Yeah. I'll give Fiona one more.
I'm getting fit
because
as
I
you-
know she's keen. Obvious risk, Fiona. Different for a 10-year-old child to an adult, or
Which, well, I suppose a defendant has a duty to a plaintiff. So all kinds of plaintiffs. It's not just
4 foot 10.
you. That's right.
With small hands.
In relation to the reasonably suited by education, training and experience, it's often the case that it seems to me that people will not have any job for which they're reasonably suited at the time they become disabled, so say the 6 months after a waiting period. But they actually then go off and do some retraining, and that changes their employability. But it seems to be unclear about whether or not at what point you actually assess it, because if you assess it at the time they become disabled, they're not reasonably suited. If they go away and they do something else, they may later have a capacity for some alternate work. That's because of a change in circumstances.
Yeah. Odd area. There's some authority for the proposition that if somebody could be retrained to do something, then that's to be disregarded because you're looking at it at a fixed point in time. Against that, there's the argument that the duty of utmost good faith and mitigation of loss requires you to take reasonable steps, and if that's training, then that's training. It'll depend very much on the individual, and if it runs in court, dare I say, it's going to depend on the appeal of the individual. If the individual looks relevantly disabled and needy and genuine, okay, they'll get the money. If they don't, not so much. So it's a rubbery thing.
I think that's about time. Going. No more questions. Thank you everybody for your attendance. Thanks to Chris and Fiona, both very thorough presentations. If you do have any queries about futures, Luke Hales is the man down in the back corner. He's the man to speak to. So thanks very much for coming.